5 seconds to go. Start. Counsel for the state relied on the testimonies of PWs 2 and 3 to contend that they had deposed convincingly that the third appellant was last seen holding the deceased boy's hands on 8th October 1999. PWs 4 and 5 deposed to having seen the deceased boy the next day early morning in the company of the first two appellants. These facts conclusively established the appellant's guilt. As may be gathered from the previous discussion, that the concurrent conviction of the appellants rests entirely on the last seen theory upheld by the courts below. The deceased, it has been held, was seen by PW2 and PW3 with the third appellant Hushan Jahan on the afternoon of 8th October 1999. She was holding his hand. The boy went missing. His father PW1 and other family members searched for him. No report was lodged at that time and the search continued. The boy's body was discovered partly buried on 10th October in an open agricultural field in another village, Narayanpur. Post-mortem was conducted the next day, that is, on 11th October 1999. The inquest proceedings too were held that day. PW1 stated that he attempted to lodge an FIR on 12th October 1999 against the present appellants but without success. The FIR was eventually lodged pursuant to an order under section 156(3) CRPC upon an application dated 19th November 1999. Investigations were conducted by PW8 and later from 2nd December 1999 by PW12. The appellants were arrested and charged for the offences and later convicted. The testimonies of PW2 and PW3 were relied upon to prove that Hushan Jahan, the third appellant and sister of the first two appellants, was seen in the company of the deceased on 8th October 1999 at 3:30 pm. PW2 claims to have informed this to PW1 on 10th October 1999 at 12 pm before the deceased's body was found, that is, at 1 pm. On the other hand, PW3, who claimed to have witnessed Hushan Jahan holding the deceased's hand on 8th October 1999, informed PW1 about noticing this on 12th October 1999, since he had gone to visit his son to Bijnor during the intervening period. The other circumstance is that the boy was seen last in the company of the first two appellants by PWs 4 and 5. For the moment, if the delay in recording the FIR, which is 42 days, is ignored, the salient fact which stares at one's face is that the conviction is solely based on the testimonies of these two set of witnesses. PW4 deposed to having seen the deceased with the said appellants early morning on 9th October 1999. He claims to having informed the boy's father PW1 about this fact after discovery of the body on 12th October 1999. PW5's deposition seeks to corroborate that of PW4. This witness also claimed to having seen the boy on the morning of 9th October 1999. However, intriguingly, despite noticing him in the company of two accused and despite having heard a cry from the boy, this witness did not look back. In terms of his admission, PW5 is a cousin of PW1. Therefore, his behavior in not interceding upon seeing the boy in the company of the accused early morning away from his house, given that the boy was only 7 years, is unnatural. It is also unnatural that since the prosecution and PW1's allegation is that the accused had a previous enmity with him, PW5, a close relative, was neither surprised nor did anything to intervene when he saw the boy in the company of the first two appellants. Another important aspect is that the police statement of PW5 was recorded more than 2 months after the start of investigation. Even the application under section 156(3) CRPC does not mention that he had witnessed the boy with the accused, despite the witness's statement that he informed PW1, the boy's father, on 12 October 1999 about what he saw on 9 October 1999. PW4 deposed that his house was 8 to 10 paces to the north of house and that he was in his house the whole of the night of 8th October 1999. He also deposed to going out in the morning of 9th October 1999 to answer the call of nature at around 6 am when he noticed that the deceased was with the first two appellants. In cross examination, he admitted to not going out of his house on 9th October 1999. He also deposed to having not been in the village when the boy's body was found. Interestingly, in his cross examination, he stated that stop.